Today we are going to be looking at the area of company law. Businesses differ in size and activity, from the simple sole trader operating on the high street to large global multinationals, often taking the form of public limited corporations. In legal terms, a business can generally be referred to as an undertaking, or more specifically a company, and the law regulating such entities is simply known as company law. The word company is a general legal term describing a collection of legal or natural persons coming together for an express purpose that can take different legal forms. In the UK, the word corporation is used to describe a specific type of company recognized in law as having a separate legal personality. The word company is used generally to describe corporations and can also be used to describe other types of business formations. However, businesses such as partnerships are not referred to as corporations or companies, and instead, words such as firm are often used to describe them. On the contrary, in the United States, the word corporation has wider meaning and can apply to business entities such as partnerships and separate legal entities. As there is some confusion as to the use of the term corporation, in this text the term will be used in the sense of a separate legal entity or body corporate. Now let's take a look at the different types of companies. The best known type of company in the Anglo-American world is a corporation, although other forms of business formation also exist, such as partnerships or sole proprietorships. Let's take a look at corporations. In common law jurisdictions, separate legal entity corporations share certain common characteristics, namely a separate legal personality, limited liability, shares normally transferable representing their underlying value or worth, and a centralized management governed by a board of directors. Thus, a corporation is a legal entity having its own existence, not unlike a natural person for the purposes of the law. As a corporation has a separate legal identity, it will continue to exist indefinitely until the moment it is wound up by its members or is liquidated by its creditors, in the event that it is unable to pay its debts. The defining characteristic of a corporation is that it enjoys legal independence from its shareholders. Consequently, if a corporation fails, shareholders enjoy what is referred to as limited liability, i.e., they will only lose the money they actually invested in the company, and they will not be held responsible for its debts. So that members of the public will be aware that they are dealing with a business that is a legal entity separate from its investors, corporations are normally identified through use of abbreviations such as Limited, Ltd, PLC, Public Limited Corporation, Inc, Inc, Incorporated, or Corp, standing for corporation. One of the major negative features of a corporation is that it effectively imposes a double taxation burden on its owners. Thus, the corporation is taxed directly on its profits through the imposition of corporation tax, and thereafter the corporation's investors or shareholders are taxed again on this profit if and when it is distributed to them by way of dividend. As a corporation has a separate legal identity, enjoying its own legal capacity and legal rights, it can sue and also be sued, i.e. it can bring actions against third parties in its own name. Consequently, state authorities investigating a company, for example, the competition or tax authorities, must respect the corporation's human rights and allow it a fair hearing, etc. Failure to do so will allow the company to successfully invalidate the investigation and avoid any fine that may have been imposed on it. It is also possible in some common law jurisdictions, such as the United Kingdom, to form unlimited liability companies, but they are relatively rare as shareholders are considered to have unlimited joint and several liability. However, such companies do have the advantage of not having to make their financial statements public, i.e. they do not have to file their annual accounts with the Companies Office. This offers greater secrecy to investors, and this is its major advantage. Now let's take a look at partnerships. A popular form of partnership is a limited liability company, or LLC, also referred to as limited liability partnerships, LLP, depending on the jurisdiction concerned. An LLC is a hybrid business formation created by different US states over the last 20 years. LLCs are attractive because they allow their members to enjoy the limited liability features of a corporation, but are treated as pass-through entities for tax purposes. In other words, they are said to be tax transparent. Each state has its own LLC legislation, and some states have developed specific LLC structures whereby the limited liability of its members is restricted to certain types of legal action, or where the structure is required to pay limited tax along with its members. However, the standard LLC in the US offers members the benefits associated with corporations and partnerships, namely limited liability, corporations, and a non-imposition of a double taxation burden, partnership. Unlike corporations, LLCs have a limited lifespan depending on the legislation in the US state in which they are created. The UK equivalent to an LLC is a limited liability partnership, LLP. An LLP is a body corporate, and thus the members enjoy limited liability. Like LLCs, LLPs are treated as pass-through entities, and consequently members are only taxed once on their earnings. Unlike LLCs, there is no time limit placed on the lifespan of an LLP. Both LLPs and LLCs are much loved by law firms and accountancy firms, as they allow them to develop global strategies without incurring unmanageable risk. It is also possible to form limited partnerships, an LP, in most common law jurisdictions. An LP creates two types of partners, one of which enjoys limited liability and the other of which does not. Investing partners benefit from limited liability, but unlimited liability is imposed on the general partner responsible for the day-to-day running of the partnership. LLPs have to some extent been eclipsed by the appearance of LLCs and LLPs. There is another form of partnership called a general partnership. A general partnership, or GP, is also a pass-through business in which the partners, who are also the business owners, share directly in its profits and losses. From a tax point of view, GPs are more advantageous than corporations insofar as the partners are only taxed once on the profits of the partnership. As we have seen, corporations must pay corporate tax on their profits, which are then distributed to the shareholders, who must also pay income tax on the money they receive. However, a negative aspect of a GP is that the partners, unlike the owners of a corporation, do not enjoy limited liability and thus are exposed financially should the business begin to lose money. Moreover, they are jointly and severally liable for the actions of other partners. Consequently, if one of the partners decides to take all the money out of the business and to disappear to an island in the sun, the remaining partners will be liable for the missing monies. In common law countries, partnerships are normally established pursuant to a partnership contract drawn up between the partners, who are free to agree any terms they wish. Now let's take a look at sole proprietorships, or sole traders. Like a partnership, a sole proprietorship is also a pass-through business that has no legal existence separate from its owner. Accordingly, the sole proprietor or sole trader does not enjoy limited liability as regards the debts of the business and is considered solely responsible for same. Sole proprietorships often carry on business under a different trading name. This explains why in many common law jurisdictions, one often sees the name of a business preceded by the words John Smith trading as. This is required by law so as to prevent a sole proprietor from being able to hide his or her identity behind a trade name. Now let's look at the winding up or liquidation of companies. Winding up is the name given to the process pursuant to which a company ceases to trade and the assets and property of the business are redistributed amongst the company's investors and creditors. Winding up can be referred to as dissolution or liquidation of the business. The winding up may be a compulsory liquidation, or an administration or receivership, or a voluntary liquidation. Compulsory liquidation. Compulsory liquidation, also known as creditors' liquidation, is a process whereby the company's unpaid creditors apply for a court order to have the company declared bankrupt. Instead of forcing the company to cease trading, the court can alternatively order that it be put into receivership or administration. Administration is a process whereby an expert administrator is appointed to the business to see if it is possible to restructure it and keep it functioning as a going concern, whilst at the same time ensuring that creditors get paid. In comparison, the aim of a receivership is to secure repayment of debt for secured creditors. Finally, a voluntary liquidation, also known as a shareholders' liquidation, occurs when a company's board of directors adopts a resolution to that effect. We hope you enjoyed this introduction to the area of company law.